Committee on Transportation Infrastructure and Public Safety will come to order. Let's call the roll.
Senators Fitzwater.
Here.
Schnelting. Here. Brown. Gregory. Shore.
Here.
Washington. Washington.
Here.
Weber.
Here.
Great, you just came into quorum being established. I move that we go into executive session. Having a second, all those in favor say aye. Aye. Opposed, no. The ayes have it. We're in executive session. I move that Senate Bill 254 be brought before the committee. Do I have a second? Having a second, all those in favor say aye. Aye. Those opposed, no. The ayes have it. The bill is before the committee. This bill is presented by Senator Bean. It requires that drivers stop at railroad crossings for any on-track equipment in addition to trains. Any discussions on that bill? Seeing none, I move that we vote Senate Bill 254 do pass. Do I have a second? Second. Any further discussion? Seeing none, let's call the roll.
Senators Fitzwater.
Aye.
Schnelting. Brown. Gregory. Shore. Washington. Weber.
No.
Senator Shore.
Change my vote to a no. By a vote of 2 to 4, you voted down Senate Bill 254. I move that Senate Bill 173 be brought before the committee. Do I have a second? Having a second, all in favor say aye. Opposed, no. The ayes have it. The bill is before the committee. This bill is presented by Senator Weber. It creates a task force regarding the security needs of nonprofits in the state that could be targets. Is there any discussion on the bill? Seeing none, I move that we vote Senate Bill 173 do pass. Having a second, any further discussion? Seeing none, let's call the roll.
Senators Fitzwater.
Aye.
Schnelting. Brown. Gregory. Shore. Washington.
It's Weber's. Senator Weber's. It's Senate Bill 173. It creates task force regarding the security needs of nonprofits. I don't think this is the time in the midst of a roll call.
I'll vote yes.
Senator
Weber.
Washington is an aye. Tough crowd. Very tough crowd. By a vote of 6-0, you voted do pass Senate Bill 173. I now make a motion to exit executive session. Having a second, all those in favor say aye. Aye. Opposed, no. The ayes have it. We're out of executive session. We'll go into the hearing. Senator Schnelting, you're up first. Senate Bill 162.
Thank you, Mr. Chair, members of the committee. Here to present Senate Bill 162. If you have traveled for any length of time through the state of Missouri on our highway, our two-lane highway systems, you probably realize that we have a problem as it pertains to congestion. Oftentimes, for whether it's 10 miles, 20 miles, or 50 miles, you have someone that's sitting in the passing lane when they should be getting, switching lanes and getting over, abiding by our Keep Right laws. I've had a lot of constituents actually bring this to me. That's the reason that I filed this legislation. This is an issue for a lot of my constituents who travel to on Highway 70 to Columbia for work, or to the west of my district. So I sponsored this bill, which would just bolster our Keep Right laws. It does a couple things. It instructs MoDOT to place signage along our major highways, warning travelers of our Keep Right laws. Some states, about half of the states, have or don't have Keep Right laws, so many of our out-of-state travelers actually are unaware that they actually need to get over once they pass. It calls for greater enforcement from Highway Patrol. It provides enhanced penalties for those who are repeat offenders, and it also ensures that our driver's ed program in the state of Missouri provides a greater emphasis on our current laws. With that, I'm able to take any questions, Mr. Chair.
Any questions for the sponsor? Seeing none, anybody here to testify in favor of the bill? Senate Bill 162. Anybody here to testify in opposition? Senate Bill 162. Anyone for informational purposes only. That'll conclude the hearing. Senator Schnelting.
Thank you, Mr. Chair.
Thank you. We'll now go to Senator Brown. Is Senator Brown in the room? Yes. Oh, there he is. Senator, you can proceed when you're ready.
Thank you. For the record, I am Senator Ben Brown of the 26th District, and I'd like to thank the committee for the opportunity to present Senate Bill 363. This bill aims to ensure due process for those put in one of those impossible situations where someone may have no other choice but to use a firearm to defend themselves or their families. Missouri currently has a version of a stand your ground law that has been in place since 2016. However, compared to the version of this bill that's been passed in nearly 20 other states, ours unfortunately falls very short. The issue with Missouri's law is that rather than being presumed innocent until proven guilty as you typically would in other areas of the law, the opposite is in fact true. Moreover, Missouri gun owners can be arrested following a threatened or actual shooting, even in cases of self-defense, without so much as probable cause that a crime has been committed. This flies in the face of one of our country's founding principles. The presumption of innocence is a cornerstone of our system of justice and a right that has been enshrined in the United States Constitution. The Fifth Amendment was intended to guarantee that every person accused of a crime is considered innocent until proven guilty, and that the burden of proof rests on the prosecution to demonstrate guilt beyond a reasonable doubt. As we've seen, unfortunately, this is not always the case. Far too often, the impacts of Missouri's current stand your ground law could be described as simply too little too late. In fact, the stand your ground protections in our state don't take effect until the trial process. This bill would establish a process for gun owners to assert this defense in a pretrial hearing, potentially sparing them from a malicious prosecution. It also restores the presumption of innocence to gun owners following a threatened or actual defensive shooting, ensuring due process and forcing guilt to be proven in a court of law. However, I will point out that this bill does continue to allow Missouri law enforcement to fully investigate alleged crimes and our county attorneys to bring charges as the evidence dictates. Thank you, and I'd be happy to answer any questions.
Questions for the sponsor? Senator Washington.
Good
Proceed.
afternoon, Senator.
Hey, Senator, I had a feeling you might have a question.
Yeah. So my first question is, what do you think it means to be innocent until proven guilty?
What do I think it means to be innocent until proven guilty?
Uh-huh.
I think that, in our society, we don't want to live in a place to where, people could just be picked up off the street without having any probable cause of a crime being committed. I think, you see that unfortunately, and it's something that our society's trying to combat. People get picked up because, simply their appearance, what they're wearing, the color of their skin. I think that's wrong. I think that we need to ensure due process for every person.
You are aware that due process doesn't start until you get into the court system. So one has to be charged with a crime before we can invoke innocent until proven guilty. Do you understand that?
I do understand that. I don't understand the point that you're making, though.
Because your testimony did not indicate that you quite understood that innocent until proven guilty is a part of our court system. Mm-hmm. And it's not, it's not don't pick me up because you may or may not think I had a crime. It's after you are charged with a crime, you are innocent until the prosecutor proves you guilty.
Yes, I agree with you. However,
whether you agree or not, that's the law and that's what it is.
Yes, but there is something called probable cause. You can't.
And probable cause is there before one is arrested, before there is a warrant issued for one's arrest.
Yeah, I would consider the requirement of probable cause for someone to enter your house, to place you under arrest, as part of due process. if you disagree, I think that we're
I'm not
talking
disagreeing.
semantics.
Probable cause is there. There is no one arrested without probable cause.
But would you
A
consider
judge
that
will
part of
not
due
issue a
process?
warrant without that.
Yes, but would you consider probable cause part of due process?
It is.
Okay, so that would be. I mean, that would then in that case then due process would take place before the hearing because
I never said it wouldn't take place before the hearing. You're saying that
maybe I
one
misunderstood.
should not be just arrested to be arrested.
Yes.
And that interferes with innocent till proven guilty. Before one is arrested, even in my community who are arrested at a higher rate than anybody else, there is a probable cause statement presented to a judge before a warrant is issued. That's how we determine what the bonds are, if there should be a bond, what is the risk factor of the person picked up, and all of those things. But I just wanted to educate you on that. My real question is, you want to change it so that the burden of proof becomes, if I think that I should use force, then that's okay.
if you do it that's in a way that's justifiable under current law. So this only allows if it's justifiable force as defined by current state law, section 563.031. I believe that's on the first page of the bill. That's all current law. So it would have to be justifiable force under existing law. So
That's
that
not
would
what
not
your
change.
bill specifically says. There should be a presumption of reasonableness under this section that the defendant believes such force was necessary to defend himself or herself from a third person from what he or she believed to be the use of imminent force. That is not our current law. The current law is what a reasonable person will believe, not just what I believe. Do you know or have you heard of a young man named Ralph Yarl?
I'm not familiar with them.
Ralph Yarl was about 5 feet. He didn't die, so he is about 5 feet, 3.5, 4 inches, maybe. He might weigh 150 pounds, dripping wet, holding 25 bricks. He accidentally knocked on the wrong door, and he was shot in the face because that man believed that since a black boy was at his door, there was imminent danger. Ralph didn't have anything at all in his hands, anything at all in his pockets. He didn't even drive there. He walked to pick up his little brother. And where I believe the street, let's say he was supposed to be on 128th Street, and he went to 128th Terrace. And because of that, he was shot in the face and almost died. Do you think that that young man, because that older guy thought that he could be in danger, and the man admitted, I only shot him because he was black, do you think that he should be excluded because he believed there was danger, although there was none?
Neither, and I also don't believe that this would prevent prosecution for a crime like that. And if you look at
It does
20
if
the 20 other
the
states
standard
that
is
have
what I
passed this.
believe it does. That's exactly what it does.
Well-
if that's the case, why are we here with this
Do you
bill?
have any, this happened in Missouri?
It happened. I just said Liberty,
Okay.
Missouri.
I didn't catch that. But this is passed in 20 different states, California, and in
I
some
don't. Now
others.
you know I don't care nothing about all that. I practice law, live, reside, and elected in Missouri.
Yeah.
So I don't care what the other ones are doing.
But
I want to care what we're
my
doing.
point is that in those other states where this is passed, it's not preventing them from prosecuting those crimes.
Bring me some evidence that it did not change the standard, because your bill specifically changes the standard of the defense. So in that case, the old man would not have been able to be charged because he personally believed he was in danger. And just to let you know, he was in one of the most conservative juries in the state of Missouri, and even they found him guilty. Bless his heart, the old man did die before he could go to prison, but he was found guilty just recently. In 2025, he passed. So I don't want us in a position where someone like a Ralph Yarl, let me just give you a little history on Ralph, even though he's in Senator Gregory's district. Ralph Yarl was an all-state band young man every year. He got accepted to every Ivy League school, and thank God he lived through that. And he will tell you that my biggest scars are my PTSD now and my fear of old white folks, old white men specifically, my fear of going out on my block, going in my community. Because mind you, he lived in the community of where this happened. Thank God he was able to go to college on a full ride. But his life could have easily been ended. Or maybe you heard of somebody named Trayvon Martin in Florida. You ever heard of him?
I have, yeah. And
The same thing was used to justify the killing of Trayvon Martin, who also had nothing. Nothing on him, nothing at all, lived in the subdivision that he was in, and was shot by somebody because they didn't like what he had on. So I just want us to be cognizant, Senator, of the type of things that we're doing. This can be way more dangerous than positive.
I think, I agree that we need to make sure we have a balance. I think we both would agree that we want to ensure that due process is followed, that probable cause is needed, because just like we don't want people shot because of what they're
Do you
wearing.
have
or how
some
they look.
examples where we have not used probable cause?
To where we have
Or
not
did
used
you just
probable
do
cause?
this because this is a bill in some other states?
No, I don't have any in front of me, but I have seen some, and would be happy to put something together and send it to you.
In Missouri.
Okay.
So do you know of any off the top of your head? I mean, you're bringing this bill.
I don't have any cases right off the top of my head.
Okay, if you could bring that for us, because I don't want us doing something, because what's funny to me is y'all want to use California for stuff that's bad to the community, but then you don't want to use California for stuff that's good for our folks. Like using your food stamp card if I'm homeless, elderly, or disabled to give me some food, no additional money. So pick and choose when you want to use something, because I know they get picked on for being a blue state, and I don't even believe in all that blue-red state. I just believe that we're Americans. So I don't want to bring something because it was working in another place, and it may not be effective for us. Their prosecutors are not our prosecutors.
This is true. Yeah,
And if we don't have an example of where our prosecutors have done this, then I don't think that we should be giving people free reign with guns, and that's kind of what this is going to be doing. Thank you.
I disagree with that statement, and the reason I use California is just because to demonstrate, that this isn't limited to just red states that have looser gun laws. This is something that's been universally applied in red states, blue states, with varying degrees of gun laws. And it hasn't created issues, hasn't prevented prosecutions. And I'll try to get you more.
Sir, it has presented prosecution in California. They just arrested a gang member on the federal level because this could not allow the Los Angeles County prosecutor to arrest them on the state level. So yes, it has created issues. It is called the Rolling 60s Gang. If you want to look that up, they just got charged federally. And part of that is because they didn't get charged in the state courts. And California is different from us. They have gangs. They have things that we don't have.
What's it called? The
Rolling 60 Crips. So I would encourage you all to there's no absolute reason that bringing something like this, Senator, and I love you to death, but I got to get on you for this, that someone that would bring a bill like this has no idea who Ralph Yarrow is. That is
I wouldn't expect
atrocious.
anything less.
That is atrocious. It is irresponsible. And it hurts my feelings that you would not know about something that happened in our state and just happened. This is not years ago. Ralph is a freshman in college. This just happened to him. And I think when we bring legislation, we should really look at how it affects our community and what it has happened in the past. Thank you.
I agree. I'm just simply trying to ensure due process and that the rights as outlined by the U.S. Constitution are followed. But I appreciate your input.
Further questions for the sponsor? Seeing none. Anybody here testify in favor of the bill? Come on up. Make sure you fill out a witness form for our records. Proceed when you're ready.
Mr. Chair, members of the committee, Aaron Dorr on behalf of the Missouri Firearms Coalition. kind of rocking a pretty good head cold today, so apologies for being a little more gruff than I normally sound. We're in full support of this bill. Pages 1, 2, and the top part of 3 are all current law, just being restated in this bill. And from there, the bill does 5 particular things. It's been discussed already. I'll just do a brief overview on this. On page 3, lines 62 through 66, we establish this presumption of innocence, which of course forces the government to prove a gun owner's guilt versus forcing the gun owner to prove his innocence in a court of law. As you've already heard, about 18 states already have this presumption of innocence. The presumption of innocence does not make anybody immune from charges. It simply says the government has to prove the person is guilty, not the person who, not the reverse. And so we're not establishing a presumption of innocence to exclude charges. We're simply saying who has the burden of proof. That's the first part of what the bill does. On page 3, line 1 through 15, that's where you have the immunities from prosecution. But it's key to note, as you heard from Senator Brown, this is only if the force used was lawful as defined in current code 563.031. So it's not in the eye of the beholder. I can't choose what force I think is lawful in a self-defense situation. Current law governs that, and those actions will be held to examination in light of current law to decide whether or not that shooting was justifiable. Also on page 3, line 1, it covers the threatened use of force. Missouri Code's a little bit confusing right now on the threatened use of force. And obviously, if somebody is legally allowed to shoot somebody in a justifiable use of force situation, if that same person draws a firearm and the bad guy breaks off the attack and doesn't have to shoot that person, that's the outcome that we would all want to see. This should cover, that person should be covered from the threatened use of force, even if no force was actually used. Page 4, line 16 through 22 clarifies that a person may not be arrested without probable cause. We've heard testimony today about if that is the case, if it's not the case. We definitely have concerns that there are situations where people are arrested just because, and all too often a person who has just been involved in a shooting is coming off of the trauma of being involved in a life and death encounter, and we want to make sure they have some time to gather their thoughts before they have to answer questions. If there's probable cause they broke the law, they should be detained and arrested on site. But if not, that person should not have to worry about being arrested just because. Missouri cops oftentimes get 2 or 3 days following a shooting before they have to answer questions before their departments. This is not doing that, but again, we want to clarify a person can't be arrested just because. And finally, on page 4, line 23 through 28, this establishes a pre-trial immunity hearing process. Right now, you can assert stand your ground law as part of your affirmative defense, but at that point, you're already involved in the criminal trial process. This would establish a pre-trial hearing to allow you to assert these in advance, and if the judge agrees, you're then immune from the charges and don't have to worry about a 12-month or 24-month or even longer criminal trial. And then it would give those protections to gun owners as well. I would just clarify that. And we heard this in testimony a couple years ago, that this bill makes murder legal. And I want to talk about that for a minute. That's actually not the case, clearly not. We're talking about all this force, and it's on page 3, line 2. This force has to be force pursuant to section 563.031. That's what governs what is a justifiable use of force situation. We've also heard in previous testimony that this makes it harder for law enforcement to do their job. And I want to address that for a moment as well. On the one hand, it could be harder, I guess, to do the job, and I understand that. I don't think it should be easy to put somebody in prison for the rest of their life. I don't think it should be easy to wrap up a case of this magnitude, and I have a pretty high confidence in Missouri law enforcement to come to the right conclusion in a use of force situation. So with that, I'll be happy to answer any questions, Mr. Chairman.
Questions? Senator Washington, go ahead.
In here, quick question. Are you a lawyer?
No, ma'am.
Are you a cop?
No, ma'am.
Now that we have that established, you don't have that experience. You heard me talk about Ralph Yarl.
I did.
And I heard you mention, if the bad guy had a gun too or whatever, how would Ralph been able to protect himself?
Well, a gun doesn't give you the chance or a guarantee of self-defense, but it gives you the option of self-defense.
Just want you to understand Ralph was 17 or 16, so he couldn't have a gun if he wanted to. So he wouldn't have been able to protect himself anyway because he didn't have a gun. Give me some examples where due process and probable cause have not been used when we've arrested people who have stood their ground.
Mark McCloskey.
Mark McCloskey, did he get arrested on site?
He got arrested.
Did he get arrested on site?
I don't believe so, no.
Did he get arrested after an investigation was done and a probable cause statement was issued?
Yeah, if you want to consider
Thank
that
you.
probable cause, I'm not sure that I would, but
But you're not a lawyer.
no, but I know.
You've never been a judge.
But I know who Kim Gardner is, and we all know.
Okay,
that.
whether it's Kim Gardner or not, let's be real clear here. Kim Gardner did not issue the warrant. And I think that that's really clear. So when we come trying to change the law, especially in the criminal world, the judge issued the warrant. So they may have presented the information, but if the judge didn't like it, because it's happened to me when I was a prosecutor, they don't issue warrants. Period. Bottom line, point blank. And if you're doing this for a man who pulled a gun out on folks who was walking down the daggum street, shame on you. Told y'all should have helped that I was running for another office, because now y'all gonna get the real Barbara Ann Washington. Now, you familiar what happened at the Chiefs parade?
Yes.
How would this law affect them?
Affect who?
The shooters.
The shooters, they would be presumed innocent, just like I am if I roll a traffic light when I leave the Capitol here tonight. They'd have to then prove their innocence in a court of law, and when they're convicted, they go to prison. It doesn't give them any additional protections in court. It simply says the government has the burden to prove their innocence.
And how does that change what we already have now?
Because right now, it's up to us to prove our innocence versus the government.
No, it
to
is
prove our
not.
guilt.
It is up to the government to prove your guilt. That's why you have to have a probable cause statement before a warrant is issued, before you get that. And have you ever heard of this thing called an arraignment?
We have to. No, I'm going to back up. No, we have. We can approve. We can try to establish. Our
Have you ever been
innocence.
charged with a crime?
Yes, I have.
And what was that crime?
Speeding tickets.
Okay, that's not a real crime. Have you been charged with a crime
No,
where you
I
had to
have
go
not.
before a jury?
No, I have.
I
not.
did.
Okay.
And I am going to tell you that even with witnesses there, what happened to me as a juvenile, myself included, I said I made a mistake. I did this. I could not be arrested or held over the 20 hours without a probable cause statement taking my case forward. And I said, I did this. It was an accident. I apologize. I'm telling you I did it. But they could not move forward. They couldn't even take my statement because I didn't have a lawyer there. And I wasn't smart enough at 13 to ask for one. I didn't do a whole lot of talking after I said I did it. But, sir, please show me, besides Mark McCloskey, where we have done that in the state of Missouri, where we are taking folks without probable cause, without warrants issued, and violating their their constitutional rights to prosecute them and put them in jail.
We want to make sure we have an ironclad process.
How many of these
that
black
ensure-
folks that has happened to that you've been out there?
Do you want me to answer your questions, ma'am, or just listen? to
No,
you?
the answer is to tell me who the people are, and I want to make sure. See, that's something in the future. I'm talking about something in the past. Where have we done this? And if Mark McCloskey is your only one, I don't know the facts, the total facts of his case. I do know that a probable cause statement was issued and a warrant was issued in result of that.
So here's the reality, Senator, and you're a former prosecutor. You said so you'll know as well as anybody else in the room. The Mark McCloskey cases are the high-profile cases everyone hears about. What oftentimes will happen is a person is involved in a use of force situation. He or she is then questioned about this. He or she does not quite understand his or her rights, as you mentioned was the case for yourself when you were a minor. And he or she ends up being pressured to make a plea deal, and he or she ends up having to take a 5-year ride versus a 25-year ride. And his or her life is just as much ruined because there's not the presumption of innocence standard in effect.
Have no
And we
problem
don't
with what you're saying.
and
I
we
just
don't
want
hear-
proof.
But we don't hear
I
about
want
those.
proof. I do, because I still practice law.
Okay, we don't
and
hear
I
about
can
those
tell
cases
you
in the
that
same
I
way.
have, in 30 years, I have never had someone who didn't come into the court. The judge doesn't even have the authority to hear the case without the probable cause statement and the warrant to bring the person forward. It's the same as if I sued you for hitting me with a car. The judge can't hear the case until jurisdiction has been established.
Right. Our
And then
point is
there's
that-
this other thing that you're missing, because you want, like, what did you say you wanted here? You wanted like a special pretrial immunity hearing.
That's right.
We have those all day, every day, called arraignments.
Yeah, we want to.
And then we have a second thing.
We want to make sure.
We have a second thing called a pretrial. So I think when we bring in this, we trying to protect somebody that's shooting somebody. And yes, this will create, whether you want to believe it or not, when you say there's a presumption of reasonableness that the defendant believed such force was necessary to defend himself. If the standard is what the defendant believes, that will give the defendant the right to shoot. Thank you.
Any other questions? Ms. Witness? Thank you, Mr. Dorr. Thanks for your testimony. Anybody
you.
else here to testify in favor of the bill?
Just put that right there.
Not rushing me. Thank you, Chairman. Members of the committee, Susan Myers of the 20th, here in support of SB 363. Every CCW class, armed church security team member training, or other firearms personal defense classes I've ever been through goes over what to do if you are involved in a self-defense shooting. First on the list, once it's safe to do so, is to call 911 to report the shooting and request police and ambulance. Failure to report a shooting is a crime, yet doing so compels self-incrimination into the mix. Then add to that the fact that it being incumbent upon you to prove your actions were justified. Someone claiming self-defense should be given the opportunity to do so prior to a trial getting underway, potentially sparing them months of unnecessary anguish, damage to reputation, and legal expenses should the judge agree. This would not be an automatic slam dunk. The court would assess whether the state has probable cause to believe the defendant's use of force was not justified, considering both the prosecution's and the defense's evidence equally without favoring the state. How is that too much to ask? Some opposed to the bill argued that in a hypothetical case with no witnesses or obvious evidence, anyone can claim self-defense, insinuating people will get away with murder. I feel compelled to ask about the flip side of that. Under current law, how many have been wrongfully convicted because of a lack of exculpatory evidence to back up their story? A lack of evidence doesn't change the fact that they may truly be innocent. There are bipartisan bills in both the Senate and the House that seek to address wrongful convictions. I would think the supporters of those bills, of which I am one, would support this bill as well, as it affirms the fundamental principle of innocent until proven guilty. Thank you.
Questions for this witness? Senator Washington, go ahead.
Hi, thank you for being here, ma'am. We appreciate you coming. Real quick question. Are you mentioned something about spending a lot of money, like on legal fees. Is that what you were referring to?
Yeah. Like
Are you
if a-
aware that the Constitution provides every person charged with a crime the ability to have a public defender for free?
if they meet the financial hardship
The Constitution
level.
doesn't say anything about the money.
Okay, I'm not a lawyer, so.
Okay. So, you mentioned that they should be able to, you want the judge to be able to make a determination before they go to trial, right?
Yes,
So you heard me talk to Mr. Dorr. I'm a little rougher on Mr. Dorr and he's used to it because he's a lobbyist.
We're good.
However, do you understand our process that you are given an opportunity to what we call a pretrial?
I have no.
Okay, so
court-
we already give that to defendants. We give them a pretrial. They're provided that opportunity before, and the defendant doesn't even have to say anything. They can sit right there, and the prosecutor has to prove their case to the judge at that time. And then the judge makes the decision as to whether or not the case would move forward.
I'm not allowed to ask you a question for clarification.
I don't
am
care.
In that pretrial hearing, is the judge, does he listen to defense and
If the defense wants to speak. So the defendant never, ever, ever, in any case, even if he goes to a trial, never has to talk.
But in
Our Constitution,
sorry.
even in self-defense, he can talk,
Right,
but he
in
doesn't have to.
self-defense, it's a law to report a shooting. So if you're on the phone to 911, all that is used in evidence. So right off the bat, a person who has just been through a horrific incident and is the victim is on the phone basically with law enforcement and the judge confessing to homicide or assault, however bad it was.
So
it
if
may
I'm the
be-
defendant, I would get on the stand and I would prove my part of why it was self-defense, and I'm
they should
allowed to
have
do that
prove- the state should have to prove that the victim was not justified.
and that is what the state's job is.
Well, you just said the defendant would have to prove, unless I misunderstood you there.
Well, in all criminal cases, it is the burden of the prosecutor to prove that the defendant is at fault. And if there's a one-on-one situation, or say the defendant is the only person left, then the only way he's going to be able to prove his without being any witnesses is he would have to speak on his behalf, because there's no one else to speak on his behalf.
Well, that sounds good, and it sounds like what the bill wants to do. So
No,
I
the
don't
bill says that I get to
understand
say I shot you because I believe that I was okay with shooting you, not whether that's a reasonable standard for shooting you. So you heard me talk about Ralph Yarl. Poor little Ralph.
Yes.
Poor little Ralph.
why. And thank Jesus that Ralph is here and would have been, if that elder gentleman had claimed self-defense.
He did claim self-defense.
Well, thankfully.
He wasn't arrested
Ralph
for
was
over a
around
week.
to say that that was BS.
Who said it was BS?
No, I said Ralph was still with us and able to say his side of the story.
Right. So
and-
but he couldn't say it for a long time. He couldn't say it because he couldn't say anything because he was in a coma.
But the gentleman was charged
He wasn't
anyway?
charged until Ralph was able to talk.
Okay.
Okay? And so he wasn't charged immediately. There was an investigation done. The things that you all are asking for, the only difference here is with this law, he wouldn't have been charged because he believed
investigation-
that his life was in imminent danger.
Well, then the investigation could have been held open and he would have ended up being charged anyway, so.
Not necessarily. I'm black. I live in a black community. It's a whole lot of black folks out here. And let me tell you the other thing that I have a problem with about this bill. I don't want young people to have a gun unless it is for hunting or something like that. I don't want them having handguns and pistols walking through communities just randomly shooting folks.
I
Let me
believe
finish,
young
please.
people have just as much
Let-
right to self-defense.
They do not have just as much right to go
They are
shooting
part of
people.
we the
So
people.
let me finish, ma'am. Because in my community, at the Chiefs Parade, that was a young people. And he could very simply have said, under this law, I felt justified in that shooting. Because what most people don't know is it was a fight and he shot in the middle of a fight. I don't want young people thinking it's okay to go around shooting everybody because I thought I was afraid. See, if I'm in a gang, my mindset is everybody is coming after me.
Right.
And so I can shoot anybody because I believed that force was necessary. And then you can't charge me. And that's going to leave those menaces to society still out in the community. And that's what I want to protect is my community.
I want to protect the people that use force in self-defense.
But I'm a gang member, so everything is self-defense for me. And under this, it's just what I believe.
Well, then it boils down to if you were the instigator in the situation, because quite frankly, me personally, I am a Second Amendment advocate, and I believe that the Second Amendment is for everyone.
So how many of
Even
these...
if you're a gang
how-
member and
How
you're
many
sitting
of these
around
people
minding
that
your
are in jail
business,
now for guns have you advocated for?
That's why I'm saying wrongful convictions. How many?
I'm not talking about the bills. I'm talking about have you been out in the community with criminal justice reform entities or
I've been out
Moms
as a
Demand
Second
Action or
Amendment
other
advocate.
things?
I advocate for women.
You advocate here in the building?
Yes, ma'am.
Where else do you
For free.
advocate?
DC.
Okay, so you only advocate with us. You don't advocate like on behalf, you don't go to like
No,
the
ma'am.
rallies
I
or
wear-
anything.
I wear different unpaid volunteer hats. I'm
Okay.
also part of a group called they changed their name a couple years ago, Armed Women of America, where I help women that want to learn to carry and conceal and learn about safety and situational awareness.
That's very
and all
noble.
that. Yes, ma'am. I mean,
Now, do you believe that if a woman is a victim of domestic violence, it's okay for her husband to keep having a gun in the house? And if he believes that she might hurt him, it's okay to shoot her?
What
None.
charges has he been convicted of?
Domestic violence.
Misdemeanor or felony?
Either. Felony, let's put it there. Felony, he broke her arm.
A violent felony, he wouldn't, if he was convicted of a violent felony, he wouldn't be allowed to have a firearm anyway.
Misdemeanor then. And he broke her
Someone shouldn't
arm.
lose their right to carry a gun or to own a gun, have it in the home for self-defense for a misdemeanor.
Even if the person that is the victim is in the home with them. So you believe gun
I would
rights
counsel
supersede
her
everything
on
else?
having her own means of protection.
And if she don't have her gun when they get into an argument and he says, I believe she gonna kill me, and he shoots her, you think that's okay?
No, but that's where you get
But that's what
into
this bill says,
abusers.
because he believed that she was gonna hurt him. Thank you. Where you live? Where you from again? I'm sorry.
Down in southwest Missouri,
Okay.
Greene County.
Okay, you from Springfield or a smaller
Just
town?
outside.
Okay, thank
Far
you.
enough out in the country to shoot in my backyard.
Well, I mean, my family
Just
is
for the
country. I
record.
mean, I don't have a problem with the country part, but I just think we need to understand that there are different issues. Some of the things that are going on in St. Louis, and thank you to our chair for being able to pull and work with a lot of us on the crime bill. But some of those things, I'm sorry, I don't want those kids having guns to go out and do willy-nilly, which is more dangerous than if we give them this extra layer of protection. I don't want to give an extra layer of protection to organizations that are in the business of crime, and gangs are in the business of crime. My favorite rapper, not because he raps, but because of what the young man was doing in his community in Crenshaw area of Los Angeles, was shot by a gun because he used to be in a gang 10 years ago. Because somebody didn't like what he said and thought something that he said was threatening, so they shot him.
I want to tease you and said I thought we're sticking to Missouri, but I won't.
We can stick to Missouri.
I was just teasing.
We just shot 3 people 2 years ago at the Chiefs Parade. And all of those people who shot felt that they were justifiable shootings. And under this, they would not have been able to be charged. And thank God we were able to charge them under the current law, and they are sentenced. Thank you.
Any other questions?
Mr. Chairman, could I make one point of clarity real quick?
Sure. Real quick.
Just on the presumption of reasonableness, that doesn't it doesn't mean that if you believe that you have a reasonable situation to use a firearm, that doesn't mean that full stop you can't be prosecuted. That you can still, that is rebutable. Then the prosecution has
Show me in your
the opportunity
bill
to
where
come
you
in.
say it's rebutable. Rebuttable. The word is rebuttable.
Look up. I mean, you're an attorney. Do you know?
I am,
how-
and I
how-
think that you're
how would you
taking the word
define
reasonableness and not looking at your
presumption
whole
of-
sentence.
presumption of
Your
reasonableness?
it says, there shall be a presumption of reasonableness under this section
Yes.
that the defendant believed such force was necessary. That's the main part I'm talking
Yes.
about. If I say I believe force was necessary,
Then
that
the
is the
prosecution has the opportunity to go and prove you wrong, prove that you're guilty.
how you
and
gonna
innocent.
change my belief, bro?
They don't have to
Senators-
change your
Senators,
belief.
Let's let folks that are here to testify
Yeah,
on the
I'm
bill
sorry.
testify. Sorry, Senator. I'll let you have a couple closing remarks if you want them. Anybody else here to testify in favor of the bill? Hop up quick. Anybody else here to testify, or anybody here to testify in opposition to the bill? Hop up quick, come on. Make sure you fill out a witness form for our records and proceed when you're ready.
Good afternoon. Thank you. My name is Park Stevens, Texas County Prosecuting Attorney. I'm here to testify against this bill on behalf of the Missouri Association of Prosecuting Attorneys. Just give you a brief introduction about myself. I'm from rural Missouri, from Houston, Missouri, small town, Texas County. Graduated there. I spent some time in Kansas City. I lived in South Sewell Park, went to law school there, spent multiple deployments in the Marine Corps. I'm still in the Marine Corps today. Family of 3 little girls, beautiful kids. Grew up farming. So I live with guns. I've spent a lot of time in my life with guns. My mother was murdered when I was a child. She was murdered, gun violence. So if we're worried about this, I don't get on that. As recently as just a few months ago, I had a jury trial, assault first degree. I'm going to read a couple of excerpts for you because it just got vacated, and I'm going to have to try it again. So I'm going to read you the Southern District's piece of their appeal that just got to my office. In fact, if there is substantial evidence of a justification defense, which is self-defense, the trial court must give the instruction even if the defense objects to the instruction and is inconsistent with the defendant's defense. What that says is even if the defense says, I don't want it, the courts must give it. Substantial evidence is defined by means evidence putting the matter in issue. So in this case, this individual did not want that defense. They said they didn't want a self-defense. They said the gun was unloaded, and that's why they didn't want it in there. And the court vacated and said, no, you have to. So the law currently is everyone gets self-defense. And if you get to court, you're going to get it at your trial, even if you tell the judge you don't want it. That's the current law. Now let me jump forward so you understand a little more, because the Southern District, in their beautiful wisdom, they did add a little footnote that I like. Footnote 4, we acknowledge there was significant evidence of Burkett's guilt in this case. 3 witnesses testified Burkett, who's the defendant, pulled the gun out first, pointed it at victim's head, pulled the trigger, and that victim never had a gun. Burkett also fled the scene, got rid of the gun, and gave inconsistent statements to law enforcement. Only Burkett claimed victim had a gun and aimed it at Burkett before Burkett drew his gun. The state's evidence from our vantage point appears stronger than Burkett's. But when a jury is not properly instructed, appellate courts are left to conjecture about whether the defendant was found guilty on a correct and lawful basis. So what that says is Southern District agrees. The evidence was substantial, it was overwhelming, and it proved beyond a reasonable doubt the defendant was guilty. In this case, this person pulled a gun out, put it to a man's head, pulled the trigger, it misfired, clicked, started racking it back, trying to get another one in, and welcome to Southern Missouri, ladies and gentlemen. The store owner pulled a shotgun out and said, get out of my store. And he took off. At trial, he got on the stand and said, no, the other guy had a shotgun first, put it to me, and then I pulled out my gun. So ultimately, I'm going to have to try that case again. That person has a long criminal history. He has felony warrants out of multiple states. He's just a general bad person. On the flip side, ladies and gentlemen, senators, thank you. I have had to sit down with a family and say, I'm not charging someone because your son was shot and killed. I've testified before you before, Matt, told about this. I brought the family in, gave them every piece of evidence we had. It's a self-defense. And self-defense in Missouri currently is an absolute bar, if it exists. And that's up to a law enforcement officer and a prosecutor to make that in the criminal world. We have to say it's an absolute bar. If self-defense exists, you don't charge them. You don't. And if the cops are good enough at the job to find evidence beyond reasonable doubt that a crime occurred, I promise you they're just as good to find evidence it did not occur. And that can be done, and that's what happens here. What you're undercutting with this bill, as it's drafted and as it's interpreted from my vantage point in the Missouri Office of Prosecuting Attorneys, is it would say if there's a situation where 2 people in a car and one pulls a gun out and shoots the other and there's no other evidence, the person who did the shooting, you just got to take their word for it. That's what this says, and that's where it changes. I just got out of another trial last Wednesday. I've tried a few cases. It was a murder first-degree trial last week. It's change of venue from Texas County into Rolla into Phelps County. Jury came back guilty, verdict. This individual told during his initial call, he made a 911 call after he shot this person and said, someone's been shot. We didn't use that trial. He got there and said, he came at me, He was threatening me. He was going to kill me. And so I had to pull a gun out and I shot him. What he didn't know is just happenstance there's a Ring camera that disproved all that. So he was given about 24 hours. He was left out. The cops believed him until they got that Ring camera back. Then they came and talked to him and said, hey, that's not quite what happened. And then he said, yeah, it is. And then they played the video. And then he changed his tune and said, well, I better talk to a lawyer now. Jury came back and said, yeah, he's guilty. That was last Wednesday. He's yet to be sentenced, but he's being detained. He's been in jail. We, as your elected prosecutors, can make the decision when the evidence supports one way or the other. Changing the stance that we are used to, changing the current law, is asking for an upheaval of what we understand. And, much to my chagrin, our responsibility to our trial judges when they don't give the instruction to tell them. In fact, if there's substantial evidence of justification defense, the trial court must give the instruction, even if the defense objects to the instruction and it is inconsistent with their defense. They're getting self-defense. The court has made that very clear. That's the Missouri Supreme Court being cited in the Southern District, who says that. Even if you don't want it, you're getting self-defense. Why muddy it up and use this bill or this chamber as a mechanism to give more ability to kill someone or seriously harm them and say, well, I believed it was reasonable, so everyone else should. Ladies and gentlemen, thank you for your time. And again, Park Stevens, Texas County Prosecutor, on behalf of the Missouri Association of Prosecuting Attorneys, in opposition to this bill.
Questions for the witness? Seeing none, thank you for your testimony. Anybody else here to testify in opposition?
Hello, Sharon Galway-Jones here on behalf of the Missouri State Conference of the NAACP in opposition to the bill. As some of Senator Washington's comments have indicated, we have a real problem in Missouri with people not getting prosecuted when young black men are killed, particularly through gun violence in this state. I could go down a list of names, but there's obviously Ralph Yarl, who thankfully lived, Justin King, who did not, and whose murderer was actually escorted to the next county over by police and sheriff's deputies the night of the murder. And that was investigated by the family through a civil case because the prosecutor in that county chose not to. These kinds of things are unfortunately pretty common in Missouri. One just happened. Mr. Mueller, Nathaniel Mueller, up in Pike County is another recent murder that we have found, and thankfully we think there will be a prosecution in that case eventually. But just to say, putting extra barriers in place in a system that is already very heavy on prosecutorial discretion and allowing law enforcement a lot of leeway in how they do their jobs creates a situation where we are making things more dangerous in Missouri, not less. And I would just ask that you oppose the bill.
Questions for this witness? Seeing none, thank you.
Thank you.
Anybody else in opposition?
Good afternoon, Chairman, committee members and staff. Thank you so much for hearing my testimony. My name's Kristen Bowen. I am here to testify on behalf of the Missouri chapter of Moms Demand Action for Gun Sense in America. I'm here to urge the committee to oppose Senate Bill 363, which would expand our Stand Your Ground law. We know for certain that under Missouri law-abiding Missourians have the right to self-defense, including the use of deadly force. However, Stand Your Ground laws, like our state's current law, encourage armed vigilantism by allowing a person to shoot and kill another person in public even when they can safely walk away. This bill goes a step further by making it more likely that shooters avoid justice, while chilling due process for victims and the families of victims. Under current law, when a person uses force to protect themselves or another person, they have the burden of introducing that defense. Under this bill, the force used against another would be presumed to be reasonable and justified, meaning the person who used such force would no longer be required to raise the defense. These critical changes provide shooters with automatic criminal and civil immunity, denying grieving families justice. This bill would prevent law enforcement from having the ability to arrest, detain, or even charge a suspect ahead of an investigation. This bill makes defendants entitled to pretrial immunity hearings in civil and criminal cases, requiring the prosecution or a plaintiff to prove by clear and convincing evidence that the person wasn't acting in self-defense. Stand your ground laws are associated with an increase in homicide rates, resulting in more than 700 additional homicides each year. Justifiable homicide rates increased by 55% in states that enacted Stand Your Ground, while these rates increased by only 20% in states that did not have such laws. Senate Bill 363 is unnecessary and dangerous. Self-defense laws give us the right to protect ourselves and our families, and that includes using deadly force if necessary, but we do not need a law that only gives people the right to seek out dangerous situations, then shoot first and ask questions later. This bill also serves to dismantle a core practice of due process in our criminal justice system, so I'm urging the members of the committee to please vote no, and thank you for hearing my testimony today.
Questions for this witness? Seeing none, thank you for your
Thank you.
testimony. Anybody else here to testify in opposition? Anybody for informational purposes only? Hearing none, seeing none. Senator Brown, any closing remarks?
Yeah, I know a lot's been said about the quote-unquote presumption of reasonableness and what that means. I'd like to just give another example of where a presumption of reasonableness is used, and that would be, in the case of a divorce, in many states, there's a presumption of reasonableness that a child born during the marriage is the biological child of the husband. So this means that unless proven otherwise, the husband's assumed to be the father of the child, but you can still bring in DNA evidence, any evidence that's introduced that proves that presumption to be wrong. There's still that opportunity there. So I think that the claims that having a presumption of reasonableness automatically full stop grants immunity to somebody that decides to use a firearm to attack or kill somebody, I think is just ridiculous, and that's not how it's applied in other areas of law.
Thank you, Senator. All right, the next bill we're going to go to, we're going to hop around because one of our senators is going to carry this next bill from Representative Baker. So, Representative Baker, if you want to hop up on House Bill 810. I know the representatives have been very patient waiting for us to do our stuff, so thank you for that. Sorry you got to sit in here for over an hour to get to your stuff, but appreciate your patience. Proceed when you're ready.
Thank you, Mr. Chairman and committee, for hearing House Bill 810. This is a naming bill that would designate a stretch of highway in Neosho, where I live, from Kodiak Road to Cemetery Road as the Lloyd Memorial Highway. I haven't done a lot of naming bills. I've only done one in my 7 years of being in the legislature. But this one obviously means a lot to me. It almost feels a bit trivial given the circumstances, but most of you have probably heard the story of my daughter and son-in-law, Natalie and Davy Lloyd, who were murdered in Haiti, Port-au-Prince, Haiti, last May the 23rd, 10 months ago yesterday. And it's been the hardest thing I've ever faced, for sure. Nothing's come close to that. But in this kind of tragedy, as a father, you look for things to remember your child and your son-in-law in this case. And so this is one of those. It's just something that I thought I could do and should do because I'm going to tell you a little bit about Natalie and Davy, who they were, and why I think it's worthy of remembering. I would have done this would it have been someone else's daughter and son-in-law in my district or in this state who faced this kind of situation. So my son-in-law Davy grew up in Haiti. His mom and dad have been missionaries there for 24, 25 years. He knew the language fluently. He was just as much a Haitian almost as he was an American. He loved the people. He loved the country. He loved being in Haiti. And when he met my daughter and they began dating, it was something that I encouraged her to go visit Haiti because I knew that his burden was to be a missionary there full time and to return to Haiti after his years at Bible school. And so Natalie went and visited there. And when she came back, she had a big smile on her face. And I asked her, how it went. And she said, I loved it. And she said, I love the people, I love the kids. And so, that was all it took. I knew that she had what it took to have that commitment and that determination to make a difference in that place. So fast forward, it wasn't long after they got married. Within about a year after Natalie and Davey got married, they returned to Haiti. And if you know anything about Haiti, it's just a mess right now. There's gangs control about 90% of the country, and it's just in a state of anarchy. And it's getting worse every day. So if you pray, and if you think about it, pray for Haiti and pray for the people there, because it's just awful what's taking place, and the government's in shambles. There's no real safety at all in the country, especially in Port-au-Prince, where the mission was. So on May the 23rd, the gangs came into the compound there, and eventually by the time that night was over, which was the worst night of my life, the call that you never want to get, and the end of that, Davey and Natalie gave their lives for what they believed in, and that was helping the people of Haiti. And even to the very end, trying to speak the truth to evil people who would eventually take their lives. And so it's because of this that I filed this bill. It's just something that I can do to have a memorial to Davey and Natalie. And it was kind of interesting to me when I submitted to Department of Transportation that I was going to do this. They give you the options. And the stretch of road that goes from Kodiak Road to Cemetery Road is the road where the cemetery is, where Davey and Natalie are buried. And it's also a road where I have property that eventually I'm going to build a home there. And so it just seemed fitting that was the place for this memorial highway. So, and I'll leave you with this. Whenever we were cleaning out the house where Davey had built a home as a 21-year-old young man, built their own home, just an unbelievably talented young man and so capable in so many ways. But when we were cleaning that out, I found a Bible there next to Natalie's bed on the nightstand. And I sat down and began to thumb through that Bible. And I found a 3x5 card in that Bible where she had written some words, and I began to read that. And on one side it just said, "My prayer." And on the other side it said this. It said, "Lord, make me a channel of thy peace, that where there is hatred, I may bring love. That where there is wrong, I may bring the spirit of forgiveness. That where there is discord, I may bring harmony." And when I began to read that, and of course I was weeping, I began to think, what a convicting thought, that I can even try to aspire to that level of commitment that Natalie had and Davey had to give of their lives for others. And in a time that we live in where it flies in the face of our culture, people that are selfless, who would give everything and sacrifice comfort and sacrifice eventually their own lives to give to others, I don't think there's any better example of why we could name a highway in memorial of someone. And so with that, thank you, Mr. Chairman, for the time, committee for the time, and I would be happy to answer any questions.
Thank you, Representative. Senator Washington, go ahead.
Sorry for your loss, Representative. I just have one question. Is there a reason that we're just saying Lloyd and not putting Natalie and Dave's name on it?
So regretfully, the department says that they can only use one name.
Okay.
And so we had to make it the last name. I would much rather preferred it be the Davy and Natalie Lloyd Memorial Highway, but it seems as though that's not an option.
Okay, thank you.
Thank you.
Further questions? Senator Shar.
Can I inquire you?
Sure.
As chairman of the Joint Committee on Transportation, can we basically tell the department to pound sand? And we're gonna.
I don't know. Maybe we should ask. We can ask. We got some time.
Can we tell them
I
and
will.
not ask?
So, I mean, I think that's a path. Let's talk to them and see.
And is
I
the
do-
representative open to modifying that if that's what you
If
and the
that were
family
possible,
truly want?
I would much rather it be that way. But
Okay.
Okay, so a couple things. What we will talk to the department and push the issue. Secondly, we'd love for this bill to go to consent, so just
I
be
agree.
prepared for that. I think that there's going to be requests. Senator Schnelting, I believe, is carrying this over here. So when we exec on this, maybe this week, it's probably next Monday. Just be prepared for it to be a consent bill. And any other questions for the representative? Seeing none, anybody here to testify in favor of the bill?
thank you, Mr. Chairman.
Anybody in opposition? Anybody for informational purposes? Thank you, Representative. The next bill will go to Representative Bromley. House Committee Substitute for House Bill 247. Proceed when you're ready.
Thank you, Mr. Chair, members of the committee. I am Representative Bob Bromley from Jasper County, District 162. House Committee Sub for House Bill 247 pertains to motor vehicle registration. And this bill started out simply as a bill that would allow you to get a 5-year registration on your vehicle. And that bill would basically, you get a 1 or 2 year now. It would give you an option of doing a 5-year, and you would take your annual fee of, say your fee was $30, you just take times 5 and get a tab that was good for 5 years. This was combined with another one of my bills that would change the even and odd model year and calendar years, that anybody that went in could get a 2-year license registration. As it is now, if you buy a brand new car today and it was a 2024, since this is 2025, you can only get a 1-year registration. If you bought a brand new 2025 today, since the calendar year is 2025, you get 2-year registration. So that would just repeal that and allow you to get a 2-year plate anytime you wanted to. And the only caveat on this was, since there is an inspection requirement after 10 years and 150,000 miles, that we limited that 5-year registration to the vehicle being no older than 6 years on that. There was also a couple amendments added to this bill that would allow the Missouri Conservation Heritage Foundation emblem being put on there, with the $25 fee going to be deposited to the credit of the Missouri Conservation Heritage Foundation. There's also, you can, if you were honorably discharged from the military, you can get a plate recognizing your branch of service. And it was brought to the attention that we now have a Space Force, and that Space Force is not available. This would add that to this bill. And this would also allow safety inspections. This would creep up every year. 2012 or newer vehicles would not require a safety inspection as long as they remained under 150,000 miles. And there were a couple other things allowing the identification number and odometer inspections. They can be performed by an employee of a licensed new or used motor vehicle dealer. So with that, there's quite a few things in here, but they're all quite simple things, and most of these pass both individually out of the House and as a group here in this committee. So I'll be happy to answer any questions.
Thanks, Representative. I do have one really quick. We get some comments from assessors who are saying that the 5-year window prevents them from collecting personal property tax or reminding folks that they owe personal property tax. What's your answer to that, where, you know, the local counties or jurisdictions are missing out on revenue as a result of prolonging that registration period? And what's the actual impact in your mind from
So in the state of Missouri and in the United States, we depend on people to self-report. When you do your taxes every year, you fill out your paperwork, your miles, whatever, for the IRS. You put your expenses down, and we trust people to be good stewards of their information. When you have corporations, they report environmentally what they did, and the EPA or the state of Missouri DNR, they accept that data. And so I do believe there is opportunities for people to not claim certain things, and that could have a small impact, I think, on the revenue streams. But it's also, if you look at the personal property tax statements, people, I don't have any cattle myself, I don't have horses, I don't have enough chickens. We rely on people to self-report all of that information. And so I don't see this as any different than that. So I am not concerned on it. I know county assessors and collectors may be concerned.
Yeah, and I certainly want the longest registration time. I hate registering my car. I think it's such a pain in the butt. Just a thought that has come through my email. So any questions for the sponsor? Seeing none. Anybody here to testify in favor of the bill?
Good afternoon, Mr. Chairman, members of the committee. James Harris representing Carvana to testify in support of House Bill 247, specifically portions on pages 12, 17, and 18 that would help vehicle franchise license holders and kind of the speeding up the delivery of vehicles. Two things there. Right now, when we sell a vehicle, we have to have an inspection just to confirm the VIN number. We'd like that ability to do it. And the second part is if we sell a car in Kansas City that's going over to Kansas, we have to currently have a Missouri inspection and a Kansas inspection. So the wording would allow us, if it's going to a state, just to do the vehicle inspection in the state where the vehicle is going to the customer. With that, I'm happy to answer any questions.
Questions for this witness? Seeing none, thank you. Anybody else here to testify in favor of the bill? Anybody in opposition?
Good afternoon, Mr. Chair, members of the committee. I'm Angie Schulte, a registered lobbyist for the Missouri County Collectors Association. And though a 5-year title sounds great, and we've spoke to Representative Bromley about our concerns, there are drawbacks with that. And I do have a couple of county collector office holders here today that can answer questions much better than I. One thing, just as you said, we believe it encourages non-payment of taxes for 5 years. And people will get a new car, register it, and then they won't pay their taxes until they have to they either trade the car or they get a new set of tags. And then once they come in to get the registration updated, if they haven't paid those taxes, they're going to end up getting hit with about a 27% interest and penalty in addition to that. And then I'll let the guys behind me speak to it, but they have some numbers on past due amounts that they're dealing with just now with what they have in personal property taxes.
Questions for this witness? Seeing none, thank you.
Thank you.
Anybody else here to testify in opposition?
Tight quarters for a hefty guy. Good afternoon. I'm Josh Speakman. I'm a county collector and treasurer in Stoddard County. I wanted to testify in opposition of the bill for a few reasons. And I expressed this with Representative Bromley on some heartburn that the Collectors Association and myself have. Just to go through the list on delinquent taxes. For Stoddard County, we have about 12,500 accounts. Of those 12,500 accounts, if it's greater than 2 years, we have about 2,000 accounts that are delinquent. 2 years or less is about 3,900 accounts that are delinquent. Now, we mail out statements every year and then second notices every year. One of the things that I send out is a letter that says, hey, you have 30 days to respond, or if it's 2 years or more delinquent, or we could send a letter to the DMV and they could suspend that registration. One of the things that the assessors, I think, had a concern, and I've spoke with multiple assessors, and that is the fact that assessors only have to go back 3 years. So if you have a tag that's 5 years and they don't assess, I get a new vehicle now, and I don't assess that vehicle 5 years down the road, and it comes time to register the vehicle, I've got to produce 5 years worth of receipts from the tax collector, 27% per year with a $105 per year penalty on late assessment penalty. The law says that the assessor has to go back 3 years, so the first 2 years of the most profitable or most revenue collected for the political subdivisions that I collect for would be missed out had the assessor not have to go back to the full 5 years. Just those are some of the concerns. At the 5-year mark as well, collectors will outlaw delinquent taxes, personal property delinquent taxes. This year alone, we outlawed nearly 60,000 delinquent taxes. So I have a lot of heartburn just on the length of time that it takes for these taxes. Of course, I want to make life simple. I have 4 vehicles myself, notably because my wife likes to purchase things, and and I don't want to go to the DMV every year, every other year. But those are some unintended consequences I think really we should take note on. With that, I'm happy to answer any questions.
Do you have a solution for how you make it less onerous to everyday Missourians? Because property taxes, personal property taxes, only gone up to record levels the last several years. It's a real kick in the teeth to Missourians across the state. The numbers we're at, it's going to the DMV every 2 years to register a vehicle. It's a real pain in the butt to own anything in the state of Missouri, and I think relieving some of that is the path we need to go down. So what's the solution, as opposed to just saying no to this? What's the solution to that, where we're relieving Missouri taxpayers?
Well, we're getting off this bill. I have several solutions and a lot of opinions on personal property, and one of those solutions was after the COVID pandemic. You know, the assessed evaluations rolled up because of the comparables. There was a chip shortage, so there wasn't any new vehicles being sold. We testified on a couple bills a couple years ago saying, hey, an increase in value year over year we should either roll it back, change the assessment, or something to that effect. So you had an increase in personal property taxes simply because of the comparables. Those are trending back down now. So to be less burdensome, I'm not sure if a 5-year vehicle tag. Of course, you want to talk about personal property and real estate and sales tax and income tax. I think a diversified portfolio is very good. I don't think that it's best to do away with personal property if that's where you were kind of leading to there.
No, just some relief. Even if it's a percentage reduction, maybe dialing back the 33 1/3% to 30% or 25 or something where your original assessed value isn't so burdensome.
Well, there's some
caps, so we don't have a year where it's up 25% year over year, and it's just a massive pain. And by the way, it may be going down. It's going down from record levels, not that back down to pre-pandemic levels. Still much higher than it was pre-pandemic. So it's still a massive pain for Missourians in the state. It's a real burden.
No, I agree 100%. One of the things is just an increase in value is considered new construction, so that new construction is excluded from the rollback requirements set forth by the political subdivisions, most of those being schools. Of course, they get 80% of the tax revenue that I collect for. So having some kind of cap where it isn't that increase isn't considered new construction, so it's counted in the rollback provisions. I don't know if that's a solution. You're asking me solutions. I'm not here to testify, in favor of one way or the other. If you want to talk about assessment value decreases from 33 down to 20, one of the problems is going to be that money's still going to come from somewhere. The schools are held harmless, and I keep emphasizing the schools because they receive the bulk of the tax revenue. That revenue is just going to roll over to real estate. So whereas you're narrowing the pool of people that pay in, where my house is going to go up 2 or 3 times.
It'd be great if political subdivisions, whether it's counties, whether it's cities, whether it's school districts, would be willing to look at how their local residents are being impacted and lighten the burden, but that's not happening. That forces us to step in.
And I agree totally.
And swing the pendulum in a hard way.
One of the things that, and I'm proud of Stoddard County with this, we're operated off of sales tax, so I think there's a zero levy rate as far as personal and real with our county. But
well, I appreciate you coming up here, and I'm just saying that because I think just interact with counties a lot of times, and and assessors, collectors. I think there's got to be something to relieve some burden off of everyday Missourians, because that's who I hear from on a pretty regular basis. And
I do too.
there's got to be some solution here in this space. And so it's not just directed at you; it's just in general.
No,
the
I
system.
totally get it. I answer questions all the time, just with general people that come in and ask that. Who would have thought, after being 5 years in a job, that people didn't want to pay taxes, being a tax collector? I didn't know that.
It's a heck of a job to want to take on. Any questions? Senator Weber, go ahead.
Thank you, Chairman. So I came in towards the end of this, so you may have already covered it, but is it, you mentioned a 3-year look back for assessing. Would it make sense to make it 3 years rather than 5 years? Is there any appetite for that, or is that a?
You put me in a bad spot.
Sorry, I just
no.
We'll just take that as he's for it.
The Collectors Association is not in favor of a 3-year mark. However, the Collectors Association is not in favor of a 3-year vehicle tag.
Gotcha.
2 years. And the problem is, if you just look at the percentages of the delinquent accounts that I have, nearly 60% of them are 10 years or newer vehicles. It's already hard enough for someone to come up with 27% penalty and interest on 1 year and then 2 years. And historically, you're looking at about a 22% group of individuals that only pay their taxes when it's time to register their vehicle. So now you've got 22% of the people that I collect to pay out to the political subdivisions that's going to have 27% penalty and interest per year plus the $105 assessment fee.
Can I just jump on that and say, is there some path to figure out how we remove a little bit of that burden, or it just creates more problems by saying it's not going to be some statutory regulated amount of penalty?
Well, I guess I'm not following. I'm sorry.
I got other people piping in from the cheap seats.
Yeah.
But I'll ask that question to somebody later, but maybe we're making it more complex than it has to be. But appreciate Senator Weber's question. Any other questions? Seeing none, thank you for your testimony.
Thanks.
Anybody else here to testify in opposition?
Good afternoon, Mr. Chairman, members of the committee. My name is David Broderson. I am the collector in Benton County, Missouri, here to speak in opposition of the bill. Much like Josh, in October of 2024, I was charged, I had about 11,500 personal property accounts, charged with a total of $5,634,000 for the year of 2024. As of March the 1st of this year, I had 1,450 of those accounts that were not paid, and about $533,000 in taxes. If you look back a few years, I'm still on the hook for about $800,000 in unpaid personal property taxes. So pretty good hit to the county. It doesn't impact the state as much because the state, doesn't get a large chunk of that money. But the counties, it makes quite a difference on as far as that goes. I'll take a little different avenue past Senate Bill 190 a couple of years ago to give seniors some relief on their real estate taxes. We wanted to protect the people, the low-income people, from losing their homes and what such. My opinion, this bill would not really impact them much because not too many of them are buying a brand new car, but the people that are buying the new cars will figure out a way to beat the system, whether it be only assessing once every 5 years, which there is an incredible amount of people that do that. We collect taxes in my office. There's probably less than 10 days a year that we don't collect a tax every day because of somebody's car tags are due and they come in and assess and pay that day so they can go get their tags. Realistically, that's the gist of it. The look back is going to be a problem because they're going to get 2 years unpaid.
It sounds like this is already a problem whether we do anything in this space or not. Secondly, what were your numbers for 22 and 23 on personal property tax collection? Do you have those in
Unpaid?
front of you?
I do.
So it's around 5.4 million for 24.
Yes. Now, I don't have what I was charged with in 20. They're going to be very similar, but I can tell you that for 2023, I'm still out trying to collect $125,000, and for 22, $54,000.
What were you don't have your total
I don't have the
personal property
charges.
tax numbers?
I don't have the, yes, I don't
Okay.
have the numbers for those. I know I'm still out 472 accounts in 23 and 262 accounts in 22. I'm still carrying taxes all the way back
So
to
those-
2016.
But those have a tendency to resolve themselves, a good chunk of them, it sounds like, after a year or two.
Sometimes, yeah. And the reason I leave them on, like I say, by statute, the collector can write off any taxes after 3 years. If they haven't been collected, we can write that off as uncollectible. I generally leave them on because my county is, they'll move away, but after a few years, they're going to come back. And then when they come
Are there
back,
a lot of assessors that write them off after 3 years?
I'd say there's a lot of them, yes. That's the collectors. Now, the collectors write them off.
Okay.
The assessors don't.
The collectors, I'm sorry.
Yeah. The collectors
Yeah.
can write those off. Like I say, I don't. I usually hold on to them a little longer, just because simply they eventually will come back around, and then when they want to get their waiver that they don't owe any taxes, back in 2018, that was the last time you were here, and you still have a tax bill.
Okay. Any questions for this witness? Seeing none, thank you for your testimony. Anybody else here to testify in opposition? Anybody for informational purposes only?
Mr. Chairman, Andy Arnold here on behalf of the Missouri State Assessors Association. The rollback is an issue, and because Section 137, 130 only allows us to go back 3 years. You go to 5 years, you get the 2 years. If you pull it off, you get it free. We would suggest you either change 130, 137, so we can go back 5 years, or go to the 3-year license. Everything else, and you ask about why the penalties are there. It's the hook. And when I say it's the hook, it makes people pay their taxes.
Yeah, I get that. Yeah, so that makes me wonder, how much of it, if you dial some of those back, is an incentive to not pay them in the first place. So
Yeah.
I get that. Any questions for this witness? Seeing
Thank
none.
you.
Thank you, Andy. Anybody else here to testify in opposition? Or for informational purposes only?
Mr. Chairman, Tony Duggar on behalf of the Missouri Association of License Offices. We're not going to take a position on the bill. We would just like for you to consider as you're moving forward. On the bottom of page 6, it includes the fees for the state, but there are no fees, there are no transaction fees in this bill for the local license offices, which would be put in Chapter 136. And so we would just like for you to consider as you're moving forward with this bill to add our fee in 136.
Okay, questions for this witness? Seeing none, thank you for your testimony. For informational purposes only.
Thank you, Mr. Chairman, members of the committee. For the record, Steve Hobbs. I'm the Executive Director for the Missouri Association of Counties, here to testify, originally opposed, but now for informational purposes on Senate Bill 247. I caught the note from the chairman that you're looking for answers, and I think we're all in that same position. Part of this is about a little bit of fairness. I noticed that the state of Missouri took care of themselves so they can pay those registration fees 5 years in advance, so you get your 5-year license. One simple solution would be prorate the personal property tax on it, and prepay that too at the same time, or let the state try and collect theirs at the end of the 5-year period, like the taxing entities will have to do. And we've talked about school districts here. We also didn't mention the rural fire districts, the ambulance districts that are dependent upon these things. I served 11 years as a county commissioner, and I sat at my desk and I could see traffic going in and out of the rotunda. And it shocked me the number of people that came in to visit with me that were successful business people that said, oh, I got a licensed vehicle. I had to come in and pay my personal property taxes. And we're in August. And the penalties didn't seem to bother them. But penalties are a real deal if you're on a limited income. And so that's the concern on this, is that, we wish we didn't have to have the penalties. But if you don't pay your Missouri state income tax, somebody's going to come knocking on your door. Unfortunately, for personal property tax, nobody comes knocking on your door unless you get pulled over and your vehicle isn't licensed. And any of us, I drive about 35,000 miles a year in this state. And if it's not shocking to you the number of people that are driving with expired tags or temporary tags that are a year old, I'm afraid this is going to add to that problem. But I'm happy to work with the sponsor and you. I think if the state would be willing to just let people pay at the end of that 5 years, probably the taxing entities would say, hey, if it's good enough for the state, it's good enough for us too. Happy to answer any questions.
Questions for Mr. Hobbs? Seeing none? Thank you, sir. Anybody else here for information purposes only? Seeing none. Representative, any closing remarks really quickly?
Yes, I'd just like to say that I believe there are some solutions to this. I don't believe penalizing the 90 to 95% of the my constituents that regularly put this information out there and do it in an honest fashion justifies the few people that don't. But I would say that I do believe the assessors have the ability, even now, that they could go in and they could figure this out. And I think this is the problem a lot of people have with government. They know right now who paid on those vehicles last year. When you get your new list from the county, it asks you to delete or add to those. Those items that were deleted, it seems to me like in our government and with computers today, they should be able to compare a database somehow with Department of Revenue on whether or not those vehicles are still registered. If they're still registered, they could find out who they're owned by. And I believe that the government could fix this without putting the burden on the constituents back in my home district. And as far as prepaying personal property tax, what if you pay personal property tax on your truck you bought last year and you wreck it and you don't have it 4 years from now? I think prepaying taxes is a terrible idea, and I just don't see where that would work. And as we have already seen, people are either going to comply or they're not. We have 10% of the people is not going to comply, whether you make it 5 years, 3 years, or 50 years. And so I just think that my job representing my constituents is to make sure that I make it easier on people to do this. We have a lot of places where people have to go 60 and 70 miles in the state to license one of their vehicles, and I just think it puts undue burden on the citizens. So therefore, all these are good ideas. They're good discussion points, but I think this is a great bill.
Thanks, Representative. Next bill, we have Representative Kalberloh, who may be the most patient person in this building. Thank you for sitting through all of that. The whole hearing. Proceed on House Bills 296 and 438 when you're ready.
Thank you for saving the best for last.
Had I known you had literally nobody here to testify for or against your bill,
yeah, you won't have to ask for
you.
anything. So, House Bill 290. I'm Representative Jim Kalberloh, District 126, West Central Missouri, and as we say in the House, it's a simple bill, just trying to raise, as everybody knows, about July and August, you see out in the parking lots and anywhere there's a bus sitting somewhere and it says we need drivers for our school district. Some of that comes from at the age of 70, it is mandatory that you go take a driving test with the state. When those people that are 70, most of them have been driving for 10, 20, 30, some 40 years have drove, and they say, I am not going to go, I've been driving this long, I'm a safe driver, I haven't had any accidents, and I'm not going to go take a test. So they just quit at age 70. And I think we're losing good drivers to that would still want to drive. Some people say, well, are we not putting these kids in danger? every school district has, and I drove a bus for 15 years, and it was the superintendent was the director of transportation. There's some bigger school districts have a director. Those people are watching the drivers. They know if there's having any problems with the kids or if they're having any problems with driving, and they know those drivers. And if they're having problems, they're not going to hire them back. We still have to, so I think that's taken care of. I think those people are watched and they know if they're good drivers or not. We still have to, we as bus drivers have to take a DOT physical. We have to do that every 2 years, but most school districts make you do it every year, so we're not doing anything with that. You still have to take that physical for your sight and your hearing and all that's still good. We're just wanting to raise that to 75, supply some more drivers for school districts and keeping that employment there for those drivers for an extra 5 years. I would take any questions.
Any questions? Hearing none. Anybody here to testify in favor? Anybody opposed? Anybody for informational purposes? Seeing none. Any closing remarks, Representative?
I just think it'd be good for the drivers and for the school districts to see this through. Thank you.
Thanks for your testimony and for bringing your bill to us and for your patience. I'll entertain a motion to adjourn. Motion to adjourn. Any seconds? Having a second. All those in favor say aye. All those opposed, no. The ayes appear to have it. The ayes do have it. We're adjourned.